Hello viewers, welcome to our program on Immigration and You. I am your immigration attorney Michael Fulwani, and once again we have with us my partner David Nachman. David, welcome.
Hi Michael, always a pleasure to be with you here.
Okay, thank you. Let's talk about the cutoff dates for the month of April 2013. For the family preference categories, the first preference, which is for the unmarried sons and daughters over the age of 21 of US citizens, advances for all the countries by 3 weeks to March 8, 2006. The family 2A category, which is for the spouse and children under the age of 21 of green card holders, also advances by 3 weeks to December 15, 2010. The family 2B category, which is the unmarried sons and daughters over the age of 21 of green card holders, little bit good news, advances by 5 weeks to April 8, 2005. And the family third preference, which are the married sons and daughters of the US citizens, unfortunately advances only by 1 week to July 22nd, 2002. And the family fourth preference, which are the brothers and sisters of US citizens, also advances only 1 week to May 1, 2001. Now, with regard to the employment preference categories, the first preference, which is current for all the countries, including India, and the employment second preference, the advanced degree holders, is current for most of the countries except India. Unfortunately, India, they are still stuck at September 1, 2004, no advance movement. The employment third preference, the professionals and skilled workers for most of the countries except India, advanced by 8 weeks to July 1, 2007. But for India, it advances only 2 weeks to December 8, 2002. The other worker categories is the same like I said before, or the regular employment third preference, 8 weeks advancement for all the countries except India, and for India 2 weeks to December 8, 2002. The employment fourth preference, which are the special immigrants, which include religious priests and religious workers, is current for all the countries. And the employment fifth preference, the investors of $500,000 million is current for all the countries. Now, with this, we have been in the last few programs talking about the predictions for the employment categories, especially that they should expect no movement, mostly India, either a third or a second, and if there is some, going to be very little. What do you say?
Well, that was the prediction I think that we had given about 4 weeks ago, Michael, when we took a look at the numbers and also the report by Oppenheimer about where they felt that things were going. So they said that there was such a tremendous uptake, and I believe that the discussion circled around where the visas were being given to the family members, that there was so much uptake that unfortunately they didn't see that there was any possible movement. So obviously with that, we want our viewers to know that there are other ways in which you can advance your case, possibly moving to the EB1. Consider EB1 classifications. Many of our clients and prospective clients who are calling our office are sharing with us their resumes and their credentials, and now, of course, with the guidance that we have in the Kazarian case, we can take a look at your resume within those parameters with the expectation of a possibility of bumping your cases up to an EB1, which of course is current. And of course, cross-chargeability is an option. Always take a look at your case to see whether there's a possibility of cross-chargeability. Are you married to a person from Bangladesh or from Nepal or some other country where you might be able to advance your case through cross-chargeability?
Now, this prediction we talked about is up to October of 2013 generally, but I would say even beyond, because the way we see the line, the numbers, and the per country limit if continues, we are probably looking at much many years ahead also, not for this 1 year already. But some people are saying it may be a waiting period for maybe 10 years, 12 years, 15 years with the numbers that are the line it is. Except, of course, things will change if there is a change in the comprehensive immigration law. If the Congress passes that, and that may remove the per country limits, or that may also increase. As a matter of fact, President Obama's first statement that we will be talking about separately in a CIR program that we'll do, it also refers to one time increase to clear up all the backlogs. You know what that will do? If they say, okay, let us clear all, make them current, for all the backlog, and then we start fresh. That will be a big help to all those people who are waiting.
And I think that what you're suggesting, Michael, subtly, which I think is a really good point, is I can't help but to wonder whether the backlogs now, as they're being reported, are somewhat politically motivated. And that is that by having the backlogs exist, being so far back, what they're doing is they're politically motivating Congress to consider, excuse me, the impact of what these backlogs are going to be on a going forward basis. And that's why they're addressing the issues of families being separated because of these backlogs.
Okay, good. Now, let's move on to another very hot, important subject, H-1B visas. The H-1B visas filing starts on April 1st. And I'm going to have David to give you some more information on why these people who are waiting to apply for H-1B visa. Basically, the H-1B petition has to be filed by employer. But again, if you have a job offer, if you have an employer who is willing to file the petition, you should talk to the employer to start the process immediately and not wait any further period of time, because there is time to be taken in getting the LCAs approved, in preparation of the papers and filing. And although with David and me were just talking before the program that we both think that this time it may be available for a few weeks, at least in the beginning, rather than...
Yeah, I don't know that we're really in a position to state what our opinion is about the use. But I mean, I think that I had a meeting earlier this week with another gentleman who sort of has his finger on the pulse of what the major H-1B users are doing. So the major H-1B users, for those of you who are not familiar with that, are Tata Consulting, Winpro,
in India,
and yeah, exactly. Well, they're the largest users of H-1Bs.
First thing that India takes almost 40 to 50% of all the H-1s.
That's right.
Probably.
That's exactly right. And I think it may be higher than that, but that's about right. And there are specific corporations which use a lot of the H-1Bs. And so the individual...
David, interesting. I'm glad that there's no per country limit on H-1s. Otherwise, you will see a big problem for India.
Well, it's worse than a per country limit, because what we have is we have a cap on the number of H-1Bs that are being granted. So there's a
true, but India can take away as many as numbers.
Oh, right, exactly.
So there's no limit.
Right,
that's
exactly.
the point I'm making.
Exactly.
Which is good. That's why India is almost 50%, because there's no limit on how many numbers they can take away.
That's right. And So you're absolutely right, and there are several organizations, several large corporations that are big H-1B users.
In India, you are saying.
And so, right. Well, they happen to be Indian companies, and those organizations have basically, we've sort of gotten their view on what they think is going to happen, and it appears that they don't feel that there's going to be this massive surgence in applications on April 1st. So there was a release that came out, I believe it was about 4 or 5 days ago, maybe more, which specifically states that they felt that there was going to be a lottery this season. I think that if you speak to the people who are submitting these H-1Bs now, that they're not really thinking that that's exactly what's going to happen.
So let's explain the lottery, because people know what you're talking about, a lottery on H-1.
Well, I think before we get to...
It's not a lottery like a green card lottery.
No, it's what it is that the government basically said that if the H-1B, the number of H-1Bs that they receive on the first day or within the first few days is up to the number that they are allowed to grant on a fiscal year basis. And this happened, the last time this happened, I think, was in 2008, when they actually had to run a lottery. They received 3 H-1Bs for every 1 position that they had. And so what they did is they took all of the numbers, they generated random numbers for each one of the cases. What they did was they assigned those numbers to the cases, and they ran a lottery and decided which ones they were going to take and process, and then they returned the rest.
The policy is on the allocation of the numbers which are subject to the cap. First come, first serve. So let us say April 1st, they only get 20,000, then they go to April 2nd, go to 3rd. And any particular day, when the visa numbers are like finished, but they have more than what is left. Let us say what is left is 5,000, but on that day there is 10,000.
Right.
So they cannot do time-wise, 813 and 814 obviously. Then what do is what they do a lottery for that particular lot of applications that came on the day on which it is in excess of what is available.
Exactly.
Would you say that's correct?
Exactly.
And they put a lottery. I don't know how they do the lottery, but
right.
In the lottery,
they have an internal procedure.
Random
follow,
probably.
Yeah.
And those who come under the lottery are okay, and the rest is stay in line, I think. Because if the people are not able to use those numbers.
Right, then it becomes whether or not they can use those numbers.
Then they
and
can
if
go
not,
back
they
to the
queue
line.
them up automatically.
Right.
But the most important thing, I think, for our viewers to know, because this is obviously right before April 1st, is that, number one, we need about 7 days in order to be able to apply for what's called the LCA, the Labor Condition Application. So if you have an employer who's willing to sponsor you, and you have to go through a little bit of an analysis. The first analysis, at least, is if you presently have OPT, and many of our H-1Bs are coming out of OPT, the first question is, do you have the ability to get a STEM extension on your OPT? Because that will give you an additional 17 to 19 months in which you can go back into work authorization.
Yeah, but you are basically talking about students, right?
Students, that's correct. And those individuals may be able to go back in and take advantage of the next H-1B cycle. So the first thing to look at is, are you taking advantage of this H-1B cycle, or are you going to be looking at the next H-1B cycle? So I think that that's something that's important you have to look at. Then the next thing is that when you're going into the H-1B, you have to make sure that you know how to ask your employer for sponsorship. That's very, very important, and that's something that our office can help with. I know that obviously other legal professionals help to help the employee to speak to the employer about the H-1B process, how it works step by step, and what their mutual responsibilities are, both the employer and the employee. So once the LCA has been applied for and the LCA has been obtained, then we can submit the H-1B petition. So that process then rolls out. And of course, we're requesting an October 1st, 2013 start date for a 2014 start date for the individual for whom we get the H-1B.
So the important thing is also when you talk about October 1st, the law says you can file the H-1 petition anytime, but not more 6 months before the October 1st.
That's right, which is why April 1st is the filing date.
Now, with regard to the students or other non-immigrants who want to change their status from that category, present category, to an H-1 category, there is an issue also that their present authorized stay must be valid until October 1st, except the students have a little more leeway. Do you want to explain to the viewers?
Right. Well, Michael, what you're referring to is what's called the cap gap, and what the government has done, it has set up a methodology whereby if a student is still work authorized and files their H-1B, what essentially will happen is that the cap gap will be filled with an automatic extension of their OPT time, and they'll be able to continue to work in OPT for the employer who's doing the H-1B or another employer. I mean, I guess it's essentially their work authorization gets automatically extended by virtue of the timely filing of an H-1B, which is that it has to be filed before before they're into their grace period.
Somebody, last word, we are running out of time. Somebody that is in a visitor visa or some other visa which is going to expire, let us say in May or June, then it will not be possible for that person to change the status, because if visa expires on June and the year starts on October 1st, they can still get the petition approved, but without the change of status, and then may have to go out of the country and get a visa stamp from the American consul and re-enter. Or in some way, if they can extend their that particular status, is another option.
That's exactly right. And we would work with the clients, of course, to try to get an extension, let's say, of their visitor's visa to carry them beyond October 1st so that they would be able to take advantage of that change of status request.
David, thank you very much for coming on the program again. And thank all of you for watching the program. Please keep watching us on every Saturday at 7:45 p.m. and on every Sunday at 11:45 a.m. Thank you very much and goodbye.